Good afternoon and happy New Year. It is a snowy day here. I'm in my New Jersey office and it just started snowing about an hour ago. It's looking like winter is here. So happy New Year. Welcome to our New Jersey webinar series. The goal of this webinar series is to go through New Jersey workers' compensation law from beginning to end with practical tips and plenty of room for interaction, answering questions, and talking about specifics. My name is Greg Lois. I'm the managing partner here at LOIS Law Firm, and I will be leading you through this entire year's worth of presentations. And the goal is to start and kind of almost mirror the life of a case. We're going to start by talking about the basic things that we think about. I'm going to then start talking about motion practice, discovery, how we weaponize those things to create leverage in cases. Our goal here is to defend employers and take control of cases. And it's my goal to share with you as much useful information as I possibly can in the short amount of time that we have allotted. If you follow along with us each month, we tackle a different topic. And we roughly follow the outline in the handbook that I write for LexisNexis, the practice guide. So you'll see in the handout materials, excerpts, and pieces of that overall manual or guide, which is written for lawyers and judges. So there's a lot of case law citations, a lot of statutory citation, but these presentations are really meant to be in plain English and are meant to be introductory in the beginning, but ramping up as we go through the year and we get into more and more complex or complicated topics. So today's topic is case foundations, and what I really want to focus on is useful information for you in helping you create leverage and defending workers' compensation cases in New Jersey. Let me talk for just a second because it's the beginning of the presentation. I want to talk a little bit about our vision and our values here at LOIS Law Firm. Our motto here at LOIS Law Firm is great practice, great life. What does that mean? It means we want to serve clients well. We have a client focus, and that is on being responsive and putting the client first. But I also want my employees to have a great life. And for me, having a great life for my employees means that I want to provide them an opportunity to master their craft and become experts in this area of law. I also want them to work within a mature and well-run business with clear expectations for advancement and what our requirements are. I want to compensate them highly. I want them to have great benefits that protects their health and wellness. And of course, I want them to live their real best authentic life, which is outside of here. So a lot of what we do at LOIS Law Firm and the work patterns that we introduce people to and then we enforce is all about making sure people have a life outside of the law firm. I am absolutely fulfilled and passionate about defending workers' compensation cases, but this is not my real life, right? My real life is lived with my friends and family. And so we really want to allow people to have those types of boundaries in their personal life and have a balance that works for them as a professional. So that's our firm vision. Our mission, our day-to-day, is getting in control of these New Jersey workers' compensation cases. If you are defending workers' compensation cases in New Jersey, you understand you are in a relatively indifferent and sometimes hostile court system in which the deck is stacked on behalf of the petitioner to find things compensable and to make you, the employer or carrier, pay, sometimes for fraudulent or baseless claims. My job is to help you regain control of your workers' compensation case and get in charge. That's what we're here to do. And that is going to color the presentation I'm going to provide going forward. It's always going to be about how do we use the rules and the law and the case law for us to help drive these cases to close. How do we close them efficiently, effectively, and of course, ethically? So that's our challenge. The firm internally is run by a number of values, which I hope align with your values. The first one is creativity. We are here to solve problems. We want to collaborate with our clients. Second thing is we're advocates. I want to win these cases. I'm not just here to not lose or slow the bleeding. I want to put my clients in a better position, right? I'm here to create opportunity for my employees. I'm here to create opportunity for the clients that I represent and help them create leverage in their cases. That's what's important to me. Of course, the boundary on all of that is professionalism. We are bound by the rules of ethics. We have a ton of integrity, and I do want people to live their lives authentically and with balance. I don't think you can be a professional if your life is out of control. And so we do emphasize that and maintaining a healthy balance and not becoming, too focused on your professional career. And the last thing is this is all about service. So our fourth value is service, and that means we want to be as responsive as we can, and we want to build relatedness with our clients. Now, these webinars are great ways to learn. Please note, we also have handbooks you can download from our website. The handbook that's up there on the screen is written in plain English, not a lot of statutory or case citation, very practical. We also publish 4 or sometimes 5 podcasts a month, all on different aspects of workers' compensation law. And if you like podcasts, check out my partner's podcast. Christian Cison does one. It's called Third Fridays. And it's always on a sort of higher level look at workers' compensation law or the practice of law, kind of like the 201 to these presentations being more of a 101 level introduction. And he brings in guests and he has kind of an exciting presentation. It's always the third Friday of the month, so check that out. Now, each of these classes that I'm going to lead you through is about 45 minutes long. I do leave lots of time for question and answers. Please ask questions. If you're attending live, use that to your advantage. You're here live for a purpose and for a reason. I see a lot of people have logged in, so that's great. Last year, we had over 7,000, that's 2024, we had over 7,000 attendees at our webinars. And what makes them useful is when you ask questions. Type your question in. At the end of the webinar, I will read as many questions as I can and provide you with live answers. Of course, I'm going to strip out anything personally related to any specific case and try to give you a general answer. If you're thinking, I don't want to ask that question, it's a little silly or maybe dumb, or I feel like it's too simple, please ask it, because someone else is out there and probably wished you asked that question, probably had the same question as you. All of these webinars are recorded, and usually within 24 hours or so, we post them up on our website. So you are welcome to go watch them back. All right, today, here's what I'm going to talk about: acceptance, denials, investigations, controlling what we can control, a little bit about average weekly wage. It's pretty simple in this jurisdiction, and reopeners. And as I discuss these topics, I want us to be thinking about always how we stay in control of these cases and how we drive them to closure. So let's begin with simply a new accident occurs at work. Are we going to accept or deny? First, some lingo in New Jersey. The case begins with the injured worker filing what's called a claim petition in this jurisdiction. So formal litigation always begins with the filing of a claim petition. In this jurisdiction, the claimant is referred to as the petitioner. Why? I don't know. Also, entertainingly, I am a bit of a scholar of the statute. The word petitioner does not really come out in the statute. They use the word claimant a lot, but in parlance, you'll hear the judges, you'll hear opposing counsel, you'll hear the petitioners themselves. They refer to themselves as petitioners, not claimants in this jurisdiction. And because we file a responsive pleading to the claim petition, we, the employer or carrier, is called the respondent in this jurisdiction. All formal litigation begins with the filing of a claim petition. There is no required form in this jurisdiction. So if you're coming from another jurisdiction that has forms and FROIs and SHROIs and all sorts of things, you're not going to have to worry about that in this jurisdiction. In fact, a claim petition could be written down on the back of a cocktail napkin, and we could write our answer on the back of a Post-it note and mail it off to court, and that's good enough, okay? So there are no real forms that you have to utilize. There are some that are published by the Division of Workers' Compensation on their website, and those are recommended forms, but not required. The only requirement is that we have to file our answering statement within 30 days of the filing of the formal claim petition. Now, sometimes a case can start with the claimant filing a motion seeking to take over and getting control of their own medical care. In this jurisdiction, from the very beginning, in an accepted or even a denied case, you have the right to control and direct medical care. It's such an important leverage point that you have in this case. You can help shape and mold and direct these cases. You can push them to great doctors, doctors who are maybe a little less paternalistic, a little bit more effective, doctors who are more likely to find that they have a work ability. So you should never give up that right to control and direct medical care. But there is an opportunity for the petitioner to file what's called a motion for medical and/or temporary disability benefits, in which they would then take over control of the case. And again, we never want to cede that control to them. If we don't file an answer in time, the petitioner can file a motion to default us. And if it's granted, they can strip our proofs, and the judge can then just immediately make a decision. In my experience, a default is extremely rare. In fact, I've been defending workers' compensation cases in New Jersey, you ready? It's year 2025, for 24 years, all right? And in all that time, I've never had a client be defaulted. It's just the judges will, in general, enlarge time and allow us to file an answer. So a default can be filed against you, but it is rare for one of them to be actually found against you or sustained. If you are defaulted, though, you do have an appeal as of right. You can move for reconsideration. But again, if you see a motion for default filed against you, contact your defense counsel. We can generally get that fixed. All right. Should you accept or should you deny? Well, accept cases when you don't have any legal or factual objections to the compensability of the claim. Accept a case where the only issues are what is the nature and extent of temporary disability, the need for treatment, or the amount of permanent impairment. So when you accept a case, you're not saying, well, I'm agreeing that this person has a permanent impairment or has not reached a maximum medical improvement. You're just saying, I accept responsibility or liability for this case. Even an acceptance is, you should almost think about it as an acceptance without liability, because you can always change that decision down the road. When do you deny cases? Well, whenever you have a legal or factual basis to deny the case. You might also want to deny a case in this jurisdiction simply because you need more time to investigate it fully. We've all seen those cases where the claimant gets injured, disappears from the work site, doesn't tell anybody they got injured at work. A couple of months later, all of a sudden you get a claim petition filed against you and you go, what happened here? And you need a little time to look into it. Now, you can deny cases really with no penalty in this jurisdiction because you can always withdraw or amend that denial. Now, the law says statutorily that at the time testimony begins, the respondent has to state their position, whether the case is accepted as compensable or denied as not compensable. Once testimony has begun in the case, the statute says that we cannot change our position unless there is fraud or something that develops a trial which clearly changes our litigation position. So just be mindful of that. You really have a lot of selection and latitude in this jurisdiction right up until the first day of testimony. Practically, application of doing this, every answering statement, we use a form answering statement here, which is the template or the exemplar that has been provided by the Division of Workers' Compensation. There's a box 4 on that form, and it says, is this case accepted or denied? If you're not sure, my advice is generally to deny the case. Unless you want to retain control in which you might accept up front and then decide later, I'm going to dispute this matter after your investigation unfolds or as you learn more about the case. Now, in terms of defenses or denials or disputes, controversies, whichever term you want to use, let's just talk briefly about some denial reasons which are unique to this jurisdiction. So what are some of the basic boundaries or basic rules about legal controversy? The first is the statute of limitations. In a typical traumatic accident case, the statute of limitations in this jurisdiction is 2 years from the date of loss or last payment of compensation, whichever is later. And last payment of compensation is in the statute because we don't want to lull or confuse a claimant into believing that their case is accepted and then we're later going to deny it or challenge it or raise statute of limitations. So statute of limitations begins at the date of loss or the last time you paid compensation and extends for 2 years. And that's again for them to file that formal claim petition. In an occupational exposure claim, case law says that the statute of limitations begins 2 years from the date, or ends, sorry, I should say, from the date the employee knew or should have known about their condition and its relationship to the employment. So this is frustrating because it means essentially in an occupational exposure, and really we're talking about a cumulative trauma case, or inhalation, respiratory case, hearing loss cases, particularly inchoate, rather subjective claims, there really is no effective statute of limitations because so many times the person hasn't worked for you for a decade. They bring an occupational exposure claim saying, well, I did repetitive hand movements when I worked for this employer and now I have bilateral carpal tunnel, or I've got a neck condition, or whatever it is that they're claiming. And when they testify, we say, well, when did you know about this condition? And they'll say, well, when my attorney told me about it. And that's when they first decided they had a workers' compensation case. So those really, I want you to think for occupational exposure cases, it's a challenge to raise the statute of limitations because it's when the claimant should have known about the relationship to the employment. New Jersey also has a uniquely confusing notice statute. And the statute has 3 different dates in it. And again, I'm going to tell you that this is the wildest notice statute you're ever going to see. Here's what the statute says. It says the employee must provide affirmative notice, and it defines that as written notice within 14 days of the accident, or the employer is given constructive notice within 30 days of the accident. So affirmative notice means in writing, told the supervisor. Okay, that's not, I just told my colleague or I texted someone I work with. It's affirmative notice, or 30 days of constructive notice. So within 30 days, we've noticed, hey, they've disappeared from the work site. They were taken away from here in an ambulance. We don't know what happened to them. That's constructive notice. And then the statute goes on to say, however, as long as notice is provided within 90 days, and that doesn't prejudice the employer, the 14-day and 30-day requirement is relaxed. So in other words, if you don't get notice from the employee, there's no affirmative statement to any supervisor, there's nothing in writing, there's no text, there's no phone call, and they've been gone for months, they can then say, oh, I did have an accident at work. And now the burden shifts to the employer. And in order for us to say, wait, Judge, we didn't get a notice, this is unfair to us, we have to show actual prejudice. We have to show, hey, if that notice had been given to us, we would have investigated, we would have looked into it, we would have collected witness statements, we would have done an incident report. Those are all the arguments that we're going to need to make. In my experience, the judges are extremely lax in enforcing the notice requirement under the statute. And again, this notice requirement under the statute has 3 different opportunities or 3 different notice time periods for the petitioner to provide notice. So it is very favorable to the petitioner. Now, there is one exception to that crazy long notice requirement, which is in hernia claims. Hernia claims have to be reported within 48 hours of occurrence. Sundays, Saturdays, and holidays are excluded. So that Monday morning report to work and all of a sudden you have a hernia, and we're probably very suspicious that they did that in their personal life, that's going to be generally excluded from that 48 hours. But that's important. So when you get a hernia claim, the first thing you should be thinking about is, when did they tell us about it? Because we know hernias are extremely common, sports injuries or pole lifting injuries, and so we should be challenging those. All right. Let's talk a little bit about the types of investigations that we expect to be done in every case when we're going to defend them. First, employment-related documents, personnel file, witness statements, wage statement, guys. This is table stakes. This is the stuff we need to know. In the insured context, where I'm representing an insurance carrier and then I'm representing their policyholder, I'm generally going to ask the risk professional's permission before I contact that employer directly. In the self-insured context, and about 40 to 50% of our business here at LOIS Law Firm is self-insured, generally we'll have an understanding that we can contact the location or we'll communicate with the risk professional immediately so that we do that. The investigation of injury that should take place, I'm hoping that every employer has accident or incident reporting procedures in place. New Jersey does require a first report of injury. It is the only required form. However, the penalty for failing to file the first report of injury with the state of New Jersey is only $15. So in my observation, most employers fail to do so, and I've really actually never seen the penalty even assessed. So even though the first report of injury is required under the statute, it's actually rare that it's complied with. However, you should know that opposing counsel does have the opportunity, and this is in the statute and the regulations, that if the employer does collect an incident or accident report, we may have to turn that over to opposing counsel if they request it. They can also request in this jurisdiction a premises inspection, which sometimes is useful and we want to cooperate with, particularly where there's a potential for a third-party action that we can either subrogate or recover from. So that's also possible. In terms of investigation, prior claims history is very important. The Division of Workers' Compensation in New Jersey maintains a searchable database of all prior claims. So when a petitioner or injured worker files a claim against you, you automatically get access to the Division of Workers' Compensation's database. Now, the only caution I have to here, and I'm going to talk about ISOs in a few minutes, is that that database only includes any New Jersey workers' compensation case they filed. So it doesn't include any personal motor vehicle accident cases they might have, or general liabilities or commercial liability cases, or workers' compensation cases in any other jurisdiction. So although this is a boon because we can now get into the docketing system and see any prior workers' compensation claims they filed, please understand this is limited just to New Jersey workers' compensation cases. I should also tell you that New Jersey no longer requires Social Security numbers on claim petitions or for filing by petitioners, which makes the indexing or the searching of their database very problematic. And it's problematic really for two reasons. First, we have a lot of claimants with the same name. There's some common names out there, and the only differentiator would have been their Social Security number or date of birth, perhaps, or Social Security number and address. So that's problematic. The second thing is, and particularly we've seen this, moving forward, is the assumed identity problem, where we have workers who might be working under someone else's name or Social Security number, and that has really made the utilization of those prior record search less effective than it has been in the past. All right. Next topic is average weekly wage, and this is defined in the statute. Now, average weekly wage, hugely important in this jurisdiction because your benefit rates are going to be completely based on the petitioner's pre-accident average weekly wage. The good news is in this jurisdiction, it's really easy to calculate. The statute states that we're to look 26 weeks back. So basically, we do a 6-month prior wages. We take an average of the amount that they earned in that 6 months. We divide it by 26 weeks. Bob's your uncle, and it's pretty simple to come up with the average weekly wage. There are some minor rules regarding room and board. The statute requires that room and board, if provided to a petitioner, increases their average weekly wage by $25 a week. In my experience, where room and board is offered, particularly in the home health services context or housekeeping context, we're really going to look to the fair market value. And unfortunately, that can really increase the average weekly wage. So be mindful about that. Hourly workers, I'll talk about in the next slide. Tips and gratuities, they count towards average weekly wage, but only if they were reported for tax purposes. So if the petitioner claims all of a sudden, well, I was working as a parking valet at this hotel, and yeah, my on the books pay was $680 a week, but I was also making an additional $400 a week in tips. Well, unless they reported those tips, we're not counting them. So cash tips that are not reported, we should be challenging those. Calculating average weekly wage, wages, salary, it means the same thing. The statute actually says that. It's always been acceptable to simply take 26 weeks of earnings, divide it by 26. That has been the rule in this jurisdiction since 1913. So pretty simple to come at the average weekly wage. For hourly workers, we should be taking the pre-injury hourly rate, multiply it by the usual number of hours in the typical working week, in the character of the work involved. And this really only needs to be done where the petitioner did not even work maybe a full day or a full week before the accident. In general, we're going to use that 26-week look back. All right. Now, before I get into the practical tips, let me just talk about one more subject, which is the bane of everyone's existence in New Jersey, the long tail, the ridiculousness of the statute. Section 27 of the statute allows for something in New Jersey called a reopener. So if the petitioner receives a formal award of compensation, that's permanent residual disability or permanent partial disability in this jurisdiction, also called a order approving settlement or a Section 22 settlement or a judgment, any of those things, the case is subject to a reopener. And this is one of the most frustrating things in this jurisdiction. The petitioner can file one of these reopeners within 2 years of the date of their last payment of compensation. And they can claim that they have a material worsening of their condition, and then they can claim that they are entitled to more and increased compensation. Unfortunately, something like 25% of all cases are going to, that we're defending, are reopeners. And the reason for that is because A, the statute allows it, and B, the courts have been really lax about what is a material worsening. Now remember, they just had a settlement or a judgment in their case, finding they had a permanent residual disability. The statute says the burden is on the petitioner. They have to come to court and show that their condition has materially worsened. But in general, what happens is they just go back to their own paid expert, the doctor that they paid previously to find them disabled. They complain more. They say, well, everything hurts worse. And the doctor just gives them a higher number, and they come back into court and they file a reopener claim. So they're not getting more treatment in general. They're really not having an impact on their wage earning ability. You don't have to show an impact on your wage earning ability at all in New Jersey to be eligible for a compensation award at all in this jurisdiction. And so unfortunately, this has become a bit of a game. And what happens when the petitioner settles their action with you, their attorney calls them up a year from now or sends them a card or a note in the mail and says, hey, isn't it time for your reopener claim? And so this is frustrating for my clients in particular, everybody's clients. I mean, this is everyone in New Jersey is subject to these reopeners, and a huge proportion of cases in this jurisdiction do reopen. So what can you do when they reopen this case? Well, first, you should serve discovery on them and demand to see what's changed in your condition. Our practice is to always serve interrogatories. Those are written questions. We serve them as a matter of course and say, tell me about all the new medical treatment you received and how this injury has impacted your working ability. In general, when someone files a reopener, I am going to angle that case for a lump sum dismissal. I'm going to try to pay a small amount of nuisance value money to make that case go away and never be subject to reopener again, because lump sum dismissal cases paid under Section 20 of the statute are not subject to reopener. So some best practices on this: never, ever, 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 ever. Did I say never, ever enough yet? Let me say it again. Never, ever, when the petitioner files a reopener claim, send them back to the original treating physician. Just don't do it. Press for all discovery, get those interrogatories, and then after they respond to our discovery, we recommend, in general, send them back to the last defense IME doctor. Why? Because that's our expert, the last doctor generally who saw them, and that expert is going to be more likely than not to say, hey, the condition has not changed. It is still fixed, measurable, and arrested, and there's been no increase in permanent residual disability. That then positions you for a Section 20 lump sum dismissal, and we think that's the best practice in nearly all reopener cases. All right, let's move on to some practical tips. And when I think about this initial conversation we're having, this introduction to this subject, introduction to New Jersey workers' compensation law, I want to talk to you about our DFD1 strategy that we have. DFD1 stands for defend from day one. And when you're defending a litigated case, or even before you know it's going to be litigated, there are things we can do. There are outcomes that we can try to aim for, and there is leverage that we could try to create, and we can do this uniquely. Now, I'm just going to say this: so much in the workers' compensation system is arrayed against you as an employer. I've had judges say things to me like, when I say, Judge, this isn't fair, this award is out of bounds, this is too much, Judge, you're finding too much in favor of the petitioner. I've had judges turn to me and say, Mr. Lois, that's cute, you're being an advocate, but remember, Mr. Lois, this is workers' compensation, not employers' compensation. compensation. And they use that to sort of justify this liberal or generous mindset that they have in terms of over-awarding sometimes, or finding the petitioner credible despite what reality would tell us or evidence-based medicine is showing. So just recognize when you're defending a workers' compensation case, sometimes you're lucky if the court's indifferent. Oftentimes it's hostile. And we always prepare our cases like we're going to court, and I don't just have one adversary in that courtroom. It's not just opposing counsel. Sometimes it's also the judge, and the judge is acting as if they were the petitioner's attorney. They're an advocate for the petitioner recovering the maximum award against the employer. So we always have to be thinking about, okay, well, this whole system is set up to reward workers, to benefit workers, and not necessarily to be fair or to afford due process to the employer. So what can we do? How can we tilt this table back in our favor? How can we make sure that we are preparing our cases well and that we are using the advantages that we have? So that's that defend from day one mindset that we have here. And so let me talk to you about some of the things we can do. And I call this controlling what we can control. All right. Now, for so many of us, first, let me just say we're professionals, right? You're probably listening to this as a risk professional or an attorney. There's so many things I can't control. I can't control how dangerous the work is. I can't control the weather conditions on the day of the loss. I can't control the medical care that the claimant received, whether they got to a great emergency room or a not so great emergency room. I can't control what judge these cases appear before. I can't control what attorney they select, maybe off of a bus stop bench advertisement or someone who advertises during daytime TV or something. I can't control so much of what's going to set up this case and maybe change the exposure value for my client. So I focus on the things that I can control. What parts of this situation that we're in, this challenge that we are trying to mitigate, what can I do to set my client up for the best possible situation? So let's talk about what we can control. And up on the screen are 7 or 8 sort of examples of things that I think we can control. And so let's talk about them, because I think these are the places we should focus our time, effort, blood, and attention. First, before the loss. Before the accident even occurs, do we have good reporting procedures in place? Do the people that are going to respond to the accident, do they know how to take a good incident report? Do they know how to do a good job of that and make sure they preserve the right information? Have we used our advantages? Like, for example, if we're in a warehouse context or a manufacturing context, a fixed location, I should say, or even a retail context, do we know the closest urgent care to us, the place that is most likely that an injured worker is going to be taken to? Have we reached out to that urgent care? And this is something any employer can do. You can reach out to that urgent care and just say, hey, look, when one of my employees comes to you with an injury and says they got injured here at work, hey, we want to take care of that person. Please, we need the information as fast as possible. You can even sit down with them and come up with a custom intake form for you, in which you're going to look at, hey, how did they specifically get injured? What was the machinery or tool they were using? What body parts were they specifically injured? You can say, hey, when my employees come to you with an injury, I want you to have them fill out a form. And you can give them the form to fill out. So there's a lot you can do before the accident to sort of put yourself in the best position to control your risk and control your loss. And I just want to be thoughtful about that. It's also important that there is some training and understanding at the business unit level, that location level, that branch level, that they understand, here's how the workers' compensation system works at this company, here's how the chain of command is going to work, and here's the information you need to provide to that employee. You know, taking care of that employee, having that employee feel like they're taken care of and cared about, so that they don't start calling the types of attorneys who advertise on bus stop benches. That can prevent a lot of exposure and maybe a lot of litigation. Now, some you cannot prevent, right? The claimant whose brother-in-law just received a $100,000 award suing the company he works for, guess what? The highest predictor of if someone's going to file a workers' compensation claim is, number one, they filed one in the past. Number two, they have a family member who filed a workers' comp claim, correct? So they've seen someone go through the system. They know how to play the game. So, you know, some of this isn't preventable, but what is preventable, we should be focusing on, and that's something we can do before the loss. Next, making sure we are cooperating with each other and coordinating together. So much of the challenge that we face is timely reporting losses to the carrier if the loss qualifies as one that you have to report to the carrier. Now, what's the rule on that in New Jersey? Well, the rule is you only have to report losses if they are more than first aid or involve more than 1 day of lost time. So let me repeat that. What you must report are accidents where there's been more than 1 day of lost time, or there's been more than first aid. And first aid just means care rendered on site. So somebody gets a laceration using the copy machine in Greg Lois's law firm, and we stick a Band-Aid on it. Well, that's on-site first aid. Nobody lost any time. I'm not reporting that to my workers' comp carrier. And that holds true for any business. So any treatment that's provided on site, an ice pack, hey, go take a rest, go sit in the break room for an hour, go drink some water and cool off, any of that stuff, that's first aid. That doesn't count. You don't have to report that to your carrier, but everything else has to be reported. Let's make sure we're reporting that. Preserving internal surveillance data, our loss control data. In the retail context, our theft control data. Let's preserve that information. There's punch in, punch out for that day, all those things. Taking accurate statements, maybe taking photos of the scene, or maybe even preserving equipment if there's a catastrophic loss. And then coordinating that. Where does that information go to? Who are we going to provide it to? Coordinating return to work issues, right? The number one thing we want to do from a psychosocial perspective is get this petitioner, this injured worker, back into the workplace in some type of dignified employment that connects them and relates them back to the employment. That's so important for us. Let's have a system in place and a plan to do that. After they return to work, what's the job description? What are they doing? How heavy is the job? What are the ergonomics? What are the lifting requirements? What are the movement requirements? Are we videotaping it? The third thing we can control, training and rehearsing the claims team. Again, I'm going to get into this clear chain of command. Who's in charge? Who's making decisions? Particularly about the person's care, when to escalate care, when to assign a nurse case manager. All of that stuff is so important. What are the communication standards for me as defense counsel in communicating with the branch or location or accident site? Most of my clients say, Greg, we don't want you communicating, even in a litigated context. I don't want you communicating directly with the location. Why? Well, nothing's going to scare a location more than getting a phone call from a law office. Hey, I'm a lawyer. I'm calling for you. I need the manager. Get them on the phone. Whoa, we just set off alarm bells, right? So we want to be careful and thoughtful about that. We also want to collect information about the petitioner early. And please, not just in catastrophic cases, even your run-of-the-mill, ouch my back, slip and fall type cases. What information can we get from the location, from coworkers, about the person's hobby sports, gym memberships, activities of daily life? What can we start to learn about them? Because these cases that go on for years and years and years, and we lose touch with these employees, right? Because they've never returned to the employment. Finding out that key information, maybe it never can happen again. When they return to work, either before they've reached maximum medical improvement or even after maximum medical improvement, can we preserve some internal video showing the work effort and the ergonomics? Another thought, if you're providing transportation for this employee back and forth, maybe to medical appointments or back and forth to work when they are in a partially disabled context, videotaping or audio taping what they're saying, what they're telling other employees, that is fair game and useful for us in determining their activities of daily living. If investigators are going to be retained, and again, this might be necessary, particularly in the context of cases where the amount or the significance, the nature and extent of permanent residual disability is at issue, social media investigations, and of course, covert surveillance. I'm a big fan of covert surveillance. It is the ultimate, I believe, truth teller as to what the petitioner is actually able to do. Now, it is illegal for me to make them take a lie detector test, but the next best thing is to get some covert surveillance, or even better, things they've posted about themselves on social media, where they're jumping on a trampoline or water skiing on a vacation, and of course they're claiming that they can't come back to work and sit at their desk. That is incredibly useful information, and I always say pictures speak 1,000 words, and it is compelling. Judges do not like being lied to. Even as generous and liberal as they might be towards the petitioner, they do not like being seeing concealment or seeing misstatements or lies. And so if we can demonstrate to the judge that this petitioner is portraying themselves as more disabled than they actually are, that is very significant, and most judges will find them to be a fraud. Another thing that we should be really experts at and using well is selecting and recruiting experts and making choices about doing record reviews where necessary. Now, a record review is where we would simply take all the treating medicals, send them to an independent medical evaluator, but do not do a physical exam. And because you're not doing a physical exam, there is no notice requirement in this jurisdiction that you are doing a record review. And so if you think medical treatment has begun to run away, or you think that the treatment is unrelated to the workplace accident, or you have other issues or concerns, then a records review might be a useful way of determining what is the best medical utilization and trying to figure out if it's time to be more proactive in directing and controlling medical. Less often used, but you can also use record review processes to preclude other parties' use of the same expert or treater. Next, prior claims history. I love ISO reports. In every single case, an ISO should be obtained. That's so useful for us at being able to determine if this petitioner has had any prior accidents. But then during the case, I would say every 6 months or so, we should be getting another ISO, because you never know. These people sometimes are very accident prone, and they get into interim accidents, and they're not revealing those interim accidents to their treating physicians if they're still under active treatment for the workers' compensation accident. And so we want to be very thoughtful about that. The other thing I'll tell you is that I have rarely seen any opposing counsel get their own ISO. In other words, when I go to court and I say, look, Judge, we've got an ISO here, and it shows this person had 9 priors to the same right shoulder. Opposing counsel goes, oh, because they don't know that, because they don't actually spend the time, effort, blood, or treasure, or really the few $100s that it costs to get an ISO report run on their own claimants. So they don't actually know if this person that's coming to them is saying they've got a bad shoulder as a result of a workplace accident doesn't have 9 prior shoulder claims. So incredibly useful at attacking opposing parties' case. Last thing I'm going to talk about is the use of functional capacity evaluations. Now, a really well-conducted functional capacity evaluation, and remember, I'm using the word well-conducted, can be incredibly useful and powerful for us. Now, when I say well-conducted, I mean a video one that is either overseen by a physiatrist or a biomechanical expert, usually someone with a doctorate in biomechanical engineering, who is going to tailor an evaluation. And these evaluations will take between 4 and 8 hours to fully and adequately be conducted, that will really test the claimant's credibility and their workability in a very controlled and scientific manner. This can be very expensive, $5,000, $6,000, $7,000, $10,000 for a functional capacity evaluation, but that might be very little in terms of reducing your overall exposure and risk. I personally recommend the ones that are computerized and are utilizing a video system to observe all of the claimant's efforts, particularly those that are using embedded sensors to test the actual degree of effort that's being put forward by the claimant. Very useful. Now, the other thing that's useful about them is the other side, opposing counsel, is never going to get their own functional capacity evaluation to challenge yours. Why? Because they would have to pay for it. There's no provision in the law that requires us to pay for theirs. And because these things are so costly, I don't see opposing counsel doing it. Also, opposing counsel are generally inept, generally inexperienced at deposing or cross-examining the physiatrist or biomechanical expert, which means when we go to court, we say, Judge, their expert says 100% disability, mine says 10% disability, and also, Judge, I have this functional capacity evaluation, which is objective, scientific, and conducted by an expert that backs up what my expert says. The judge is going to be much more likely to agree with or find our evaluating physician credible. So even though they are costly and not right for every case, in the high exposure cases, the catastrophic loss context, a functional capacity evaluation can be a very useful tool that the opposing party does not have access to and will not have a ready means to attack or diminish. So some takeaways before I move over to questions, and I do see that a question is popping up. Let's investigate these cases. Let's be thoughtful about reopeners. Do not treat them like regular cases. And let's remember to defend from day one. There are things that we can do. There are specific advantages that we can create if we take those opportunities. All right, so I'm hoping that if you've had questions, you've typed them in here. I'm going to open up the questions panel now and answer as many as I possibly can. All right. All right, Leonardo asked me the question, what is a proof? Okay, that's kind of a general question, but the proof would be any evidence, any medical evidence, any expert testimony. Those are the proofs. And if you're talking about proofs for showing material worsening, because I did talk about that a lot in the context of a reopener, in general, the proofs that the claimant shows is their own subjective complaints. And that's why in a reopener context, we think getting a full and effective independent medical evaluation with the same evaluator who previously examined the claimant on our behalf is the most effective way to respond to those. So question is pretty short. Maybe there was more there. If you want to type it in, I will answer it. Okay, Erica asked the question, Greg, how would you suggest calculating average weekly wage when the injured worker was paid off the books and has provided an affidavit attesting to wage information and the employer has no written record of same? All right, so when you're in the sketchy situation, and this is a sketchy situation, we have to tread carefully. Employers should not be paying claimants off the books. We should be investigating that. This happens though, particularly in the construction context. I'm seeing it more and more in the food or retail delivery context. And there's needs communication with the employer. And we have to say, wait, is this person really paid off the books? The goal of establishing the average weekly wage is to establish the fair or correct average weekly wage. You're not going to hear me advocating about gaming average weekly wage or trying to come up with tactics to show the smallest average weekly wage I can demonstrate. I'm always looking for the fairest, the most corrective, the one that we can justify before the judge. So where the claimant says, hey, I was paid off the books and here's how much I was paid and here's an affidavit from myself saying here's how much I was paid. That's cute, but I also think we need to communicate with the employer and say, did you? How much? How often? And we need to come to an understanding of how this employment relationship was compensated, and we want to do that as fairly as possible. My experience too, by the way, has been the workers' compensation courts have absolutely no interest in reporting employees who receive cash payments, nor do they have any interest, or have I seen them turn over to the authorities for investigation employers who have been paying employees off the books or cash where they should not have been. It's just not something they engage in. So where the employer is concerned about that, I'll say, look, in my experience, I've been a couple decades of doing this, where the employer comes forward and says, was my employee was paid off the books, establishing the average weekly wage has generally not led to a wage and hour investigation. Now, they are obviously, if they are insured, that's going to be a problem with their carrier because they have certainly been concealing wage information from their carrier, which might invalidate their policy of coverage and can open a different kettle of worms. But I hope that is responsive to your question. So good questions. Thank you guys for joining me. Next month, we are going to talk about weaponizing discovery in workers' compensation cases in New Jersey. So please join me for that presentation, which again will be on the first Monday in February. I hope you have a great new year. 2025 is starting off here snowy, and I hope it's great for you. I hope you achieve all of your resolutions, and I will see you next month. Bye, everybody.